Good evening and welcome to the PI show. My name's Harry Nowicki. We're talking about injuries to people and the law affecting injuries. Tonight, special guests Tony Carbone and Martin Smith. And tonight we've got a topic which follows on from last week, which is alternate dispute resolution. We're lawyers, so there's always a dispute. And how are disputes resolved?
It's interesting you say that, Harry. Some of the things we discussed last week were cases that went before a judge and a jury, and eventually, in some of those cases, the jury reached a verdict. That's the end of the line. The verdict comes in, and that's what the judge enters as a judgment. There are a number of ways of matters being discussed, negotiated and resolved prior to a court.
How many cases go to verdict in personal injuries?
My understanding in the personal injuries sector is that there are 97% of cases settled without a verdict, 3% go to verdict.
So you can settle at any time. Historically, you've had the best offer on the door of a court.
Yes.
That's changed.
Yes. The cost of running litigation in a court is expensive. Obviously the government, the courts, the insurance companies, everybody is well aware the cost of running a trial adds up with experts, witnesses, doctors, fact witnesses.
Transcripts expensive?
Exactly. So every effort is made, or in the majority of cases, every effort is made to resolve a matter without the necessity of having it finalised by a court.
The parties could get a better result in court, but by the time you take into account all the extra costs, you're so much worse off. That's what we're basically saying, isn't it?
That's a factor. So if one party is concerned about costs, which is often a plaintiff, but sometimes defendants aren't always concerned about costs. But look, our Attorney General, Mr. Hulls, has released a justice statement.
Justice statement number 2. He did number 1, if I had a guess, back in 2004. This one is 2008. He has, in fact, promoted appropriate or alternative dispute resolution. He's a bit like Kevin Costner with the Field of Dreams. That is, build the show and they'll come along and play. He has a number of dispute resolution centres which have been set up around Victoria where the parties can go and sit down and attempt to resolve the matter. Before that, as you said, it used to be all at the door of court.
But so alternate dispute resolution, one change in Victoria over the last 20 years which has been significant has been that you cannot go to trial without a mediation.
Correct.
Supreme Court and County Court, which are the main courts of dispute in personal injuries, you cannot go to trial without a mediation. Does it work?
Yes, they have appropriate orders, you'd call them, where a mediation process is undertaken and the parties have to successfully or not successfully have a mediation finalised. If they resolve the matter, it doesn't go to court. If it's not resolved, it then goes to the next step.
But Tony, you've got views about how mediation works in practice in Victoria in this area.
I find that mediation's good if the parties have them a lot earlier than the trial date. More often than not, you get them too close to a hearing, and it's very hard to resolve matters at that stage, because what normally happens is you can start a mediation, then issues arise at the mediation where, as Martin says, you lay your cards on the table, and if issues arise and say you're 3 or 4 weeks out of a trial, it makes it impossible to be able to deal with them and then reconvene or get the mediator or whoever's conducting negotiations to communicate with the other party to try and resolve a matter.
In Victoria, who's the mediator?
Well, the mediator is generally a barrister at law, someone with quite a bit of experience in court, someone that's been to court quite a few times. You really need someone that's litigated because they know the ins and outs of trials, They know the costs associated with them. They know what's going through parties' minds.
Do they have to have training? Or?
They do. They do. I think Martin's probably acted as a mediator.
Yes, I'm a qualified mediator. I did a course back in about 2002, 2003. And went through the process of learning the skills of mediation. There is quite a number of leading text on it. That's from Professor Boole, and here's another one from Tanya Sorden, Alternative Dispute Resolution. Both of those people are leading lights in the mediation process or the Alternative Dispute Resolution process.
Isn't it important to actually get the parties to tell you what's on their mind, and then as a mediator it's pretty critical that you only divulge what's absolutely necessary, because a lot of information's given to a mediator in confidence.
Correct.
And Harry, it's important to get the parties to really tell you what's on their mind, because otherwise you're probably going nowhere. Isn't that right? You know, you really got to know where a defendant sits.
Well, as a plaintiff lawyer, you hope to, you've got to know your own case.
Yeah. And
you've got to appreciate or understand where the defendant's coming from and what their case is all about as well.
The mediator has a task, and that task is literally to identify the problems and the issues, and to get the parties to try and resolve those problems and
narrow
issues.
The issues that are in dispute.
As you go through each one of those steps and you narrow where the problems are and you solve each problem as it goes through, all of a sudden you're coming closer and closer to a resolution.
There's been a lot of instances where you get to a mediation, the parties are sort of rigid in their
before
views.
Before they get to the mediation.
Yeah.
And do people thump the table and are they histrionic?
You've got to know who your opponent is.
Is there a lot of passion and emotion in mediations?
There can be.
There can be. You can have the parties in there to start with. They sometimes do that for an opening. The beauty about mediation is you're in control. The distinction between a mediation and alternative dispute resolution process, there are a number of them, but the most important ones I find are you're not in a court setting, you haven't handed over the decision-making process to a judge or to a jury, as we discussed last week. You've got confidentiality. You're not in a public court where people can listen to all your medical problems.
So if someone says something in mediation,
it's confidential.
You can't repeat that outside the mediation.
And it's not to be used in court.
No.
It's got what they call without prejudice comments. They are kept for that room and kept for those parties. There's a convenience. You don't have to, go to court at 10 o'clock and finish at 4. A mediation can start early, it can start late.
Some of them go for long times. I mean, you could start in the morning and could go all afternoon. I mean, I've been in some.
Still been there at 7 o'clock, 8 o'clock.
Many years
ring
ago.
Ring up for a pizza.
Well, Harry, if that works, why not? I mean, whatever gets the parties talking. It's essentially that's what you're trying to do.
It's an informal process as distinct from the court. The court is formal, bound with court rules and procedures. This is an informal process conducted by a mediator.
Well, we're going to continue on this theme after a short break for our sponsors.